In Texas, an arrest warrant and capias are two legal documents used to get a defendant charged with a crime to court and in front of a magistrate. Another equally critical part of due process is getting witnesses to court who aren't charged with the crime and who may not want to be there for reasons ranging from fear to inconvenience. A subpoena is the means by which a witness is compelled to appear in court. According to the Code of Criminal Procedure, a subpoena may summon one or more persons to appear before a court to testify in a criminal action at a specified date or time, on a specified day before an examining court, at a death inquest, before a grand jury, at a habeas corpus hearing, or finally, in any other proceeding in which the person's testimony may be required. The person who is named in the subpoena, or in other words, the person who will be required to testify, must be a peace officer or at least 18 years old, and not a participant in the proceedings. So this doesn't mean that children can't be required to testify or compelled to testify. We'll talk about how we get a child witness to court in a moment. Also, the phrase "not a participant in the proceedings" probably means the prosecutor can't subpoena the defendant to testify at his own trial. Of course, this makes sense constitutionally. According to the Code of Criminal Procedure, a person who is not a peace officer may not be compelled to serve a subpoena, but if he or she agrees in writing to accept that duty and neglects or refuses to serve or return the subpoena, he may be punished. A court or clerk issuing a subpoena shall sign the subpoena and indicate on the date it was issued, but the subpoena need not be under seal. According to the Code of Criminal Procedure, the subpoena must include the name of the person to be summoned, the place to appear, the date and time to appear, and be issued by the clerk. Again, it need not be under seal. If a witness is younger than 18, the court may issue the subpoena to a person having care, custody, or control of the child. If that person fails to produce the witness, the court may hold that person in contempt and impose penalties. If the prosecutor or defense attorney request an attachment in order to secure the appearance of a child witness, then the attachment must include an affidavit. If the witness is in a Texas Juvenile Justice Department facility, a secure detention facility, or a juvenile secure correctional facility, the court may issue a bench warrant or direct that an attachment issue to require a peace officer or probation officer to produce the child in court. When the witness is no longer needed as a witness, the court shall order the peace officer or probation officer to return the witness. A magistrate may order a child witness younger than 17 to be detained in a juvenile detention facility not longer than 30 days, with 30-day extensions at the discretion of the court. If the witness is at least 17, the court may order them detained without bond in a county facility. If a witness has in his possession any instrument of writing or other thing desired as evidence, the subpoena may specify such evidence and direct that the witness bring the same with him and produce it in court. This is called a subpoena Duces Tecum.